Welcome to You and the Law, a Chicago Bar Association production that provides information on various legal and policy matters of public interest. I'm Mike Alkaraki, a partner at Leahy, Hoste, Alkaraki, where I represent plaintiffs in cases of serious personal injury, medical negligence, products liability, and wrongful death. I'm an adjunct professor of advocacy at Loyola Law here in the city and a member of the Chicago Bar Association, where I have served on the board of managers. On this installment of You and the Law, we have very special guests with us to discuss a very important subject. David Goldberger and Geoffrey Stone are, among other things, lawyers, professors, and First Amendment advocates and scholars. Professor Goldberger became widely known for his representation of the National Socialist Party of America, a euphemism for the Nazis, in defense of their alleged right to demonstrate in the village of Skokie, Illinois. It was a case of some controversy that over the years came to represent a tremendously profound expression of faith in the principles housed in the First Amendment. Professor Stone is a lawyer, professor, and distinguished First Amendment scholar at the University of Chicago School of Law, with a prolific body of work focusing on free speech and association rights, among other things. Thanks, gentlemen, for being part of the show. We appreciate it.
Pleasure.
I'd like to, I gave a little bit of an overview there, but I'd like you both, because you have so much you bring to the table, to take time and you don't have to rush at all to share a little bit about your background and what you bring to this topic. And why don't we start with Professor Stone, because I think once Professor Goldberger shares a little more, we're going to jump off into that Skokie case as a foundational touching point. So, Professor Stone, please go ahead.
Well, as you said, Mike, I'm a professor at the University of Chicago Law School, and my area of expertise is constitutional law, and particularly First Amendment, freedom of speech and press. I've also served as dean of the law school and provost of the university, and I worked with David on the Skokie case. Although he was obviously by far the primary figure.
I didn't actually realize that. Despite the research I did to prepare for this, I did not realize, Professor, that you were actually a part of that as well. So that's fortuitous, I suppose, for us today.
Nobody paid any attention to me, so.
Thank you. Professor Goldberger.
Well, I practiced with the ACLU for 11 years in Chicago, and during that period there was the Skokie case, and it just got notoriety beyond anybody's expectation, but it was a life-shaping experience, some for the good and some for the not so good. I've litigated other cases. I've argued a couple of times in the United States Supreme Court, and I've taught constitutional law over the years, but my particular interest has always been the First Amendment. The cases that I've handled generally have been public assembly cases, as was the Skokie case.
Sure. So I think what I like to do is consider some of the principles that were involved in the Skokie case, and attach them perhaps later on to some of the events that are happening now, because it seems to be that there is an increased focus on free speech and speech regulation and the bounds of that and what's healthy as a matter of policy. So if we can go back to your engagement in the Skokie case, and obviously you can both share your experiences related to that. But first, Professor Goldberger, how did you come to get involved in that case?
Well, I was legal director of the Illinois ACLU at the time, and we had, technically, I suppose you say it walked in the front door. We had represented Frank Collin, who was then the leader of this group, on two other occasions involving just classic free speech cases. But they were, in each case, he came to the ACLU because he had no other resource available to him to defend the rights of the group to demonstrate and otherwise spread their message. So it was from the point of view of the ACLU at that moment in its history, it was a slam dunk as to whether or not we should be providing representation.
Okay, and I wanted to hang on to that concept for just a moment about the ACLU, considering it being, you know, a slam dunk in terms of it's exactly what they should be doing, because it's not necessarily always the case. I think there are perhaps different ideas out there now. And Professor Stone, if you can share some of your experience getting involved in that case before we dig in.
Well, before that, I just want to say David was an absolute hero in this case. It was extremely controversial and stressful, and he was put under a great deal of pressure, and yet he stuck with it and ultimately won the case, which was not at all obvious at the time. I think that, you know, he deserves enormous credit for that. When I teach the First Amendment, as I do every year, and I teach the Skokie case, I always give credit to David and say this is what you students should be thinking about in terms of having courage. But the controversy itself was an interesting one. The Nazi Party decided it wanted to march in Skokie, Illinois, which was a predominantly Jewish community, and it had 5,000 survivors of the Holocaust living there. And therefore, this was a very controversial thing for them to want to do. And there was a lot of talk about potential violent responses and the like. And the city decided to try to take steps to prevent the march in a variety of different ways. And David and the ACLU challenged those on the ground that they violated the First Amendment rights of the Nazi Party in this context. And ultimately, he won. And it was a really fundamental case because it raised issues similar to civil rights marches, in which individuals were saying they were going to be violent with respect to civil rights marches, and to what extent could the government stop the march because of the threat of violence.
Right.
And so it was a wildly important and visible case, and it took a lot of courage and skill on the part of David to win it.
Mm-hmm. So there are a variety. When people hear about this, you know, and it's whether they're lawyers or lay people may have an impact, but I think that one of the principles that I think is inherent that we're going to have to dig into when we talk about this is there is this instinct that people have of just decency, of wanting to be nice and kind, and it's sometimes, I think, counterintuitive, you know, to reasonable people who want to lead with kindness, to think that it would be helpful to creating a better society to allow vile expressions of ideology. How can you discuss that tension? Either one of you can kind of, and I don't think I've articulated it perfectly, but I think you're following me. And if either one of you can kind of pick up on that, I'd appreciate that.
David?
Well, it seems to me that the whole idea of the First Amendment is that all speech is protected and should be protected insofar as it falls within the parameters of legal activity. That the civility is desirable, but it should not be enforced by the law. It should be enforced by social custom and social tradition. And that differs from what they do in Europe, for example, in England, where civility is enforced by law. And the consequences are often unacceptable from our point of view. They'll throw authors who deny the existence of the Holocaust into jail because that's not a civil thing to be saying.
Mm-hmm. And you know, to some it may be sort of self-evident what the problems are with enforcing, regulating civility. But to some, it may not necessarily be obvious. So there are two things there. One, it doesn't have to be a perfect definition, but just kind of discuss the concept of civility as you're using it. And then two, and you can both chime into why would it not necessarily be a good idea for a government to regulate and enforce the concept of civility and interpersonal interactions?
My first, to talk about what's the definition of civility, I can't give you a dictionary definition off the top of my head, but it means saying things that are really appropriate in polite society and not offensive. The problem with that is that often important messages are communicated by means of offensive communication, and the definition of offensiveness changes depending on who you are and where you're standing, so to speak. And the fact that Martin Luther King was calling people in Cicero racists is not a civil way to communicate his message, but it is in fact in a very effective way to make clear what the problems are. And today's communication is not civil by a bit. And the question is, should the government be throwing people in jail because of it? And can the government be trusted to decide which is appropriate and which is inappropriate in the marketplace of speech?
Right. Professor Stone.
Yeah, I mean, I think that it's important, first of all, to understand that the Supreme Court did not interpret the First Amendment until 1919. And in the first 50 years, for the most part, it did not give much protection to free speech. It tended to basically give the government a high degree of discretion to restrict speech. So during World War I, for example, the Supreme Court allowed the government to make it a crime for people to criticize the war or the draft. And they thought that was fine. But over the next 50 years, the court and the nation came to understand how damaging that was to a democracy. And the lesson of Skokie, which is kind of the paradigm of that at the time, is that if you allow people who object to the message being communicated to effectively get the government to shut down the speakers, then you're inviting that. And that, just as with the civil rights movement, as I mentioned earlier, if the white citizens in a town in the South wanted to shut down black marches, and they could do so by throwing rocks and by yelling and screaming and so on, then there'd be no speech. And the key thing about Skokie is it demonstrated how fundamental and how important it is to protect the freedom of speech, even when there is, in fact, a significant risk of harm in terms of damage and violence and response. And by the way, in the Skokie case, ultimately, there wasn't that, because the Nazis moved their speech to the city rather than to Skokie, not by order of the court, but because that was the more sensible thing for them to do. But you don't want to give people the incentive to shut down speakers if they have the power to do that, because you can be sure they will. Imagine a pro-abortion speaker in an anti-abortion state wanting to give a speech, and if you could shut that person down legally by just throwing rocks at them, then that's what would happen. And Skokie case illustrates that that's not possible.
Right. So when we talk about the First Amendment, generally, we're referring to, of course, not just free speech, but the freedom to associate, religious issues. There are a variety, there's a whole suite of related rights that are associated with the First Amendment. And I think you referenced a variety of those just in that quick overview there. I want to move back briefly to Professor Goldberger. Before we got started here, I mentioned this was a June 6, 2021 New York Times article. The headline is, once a bastion of free speech, the ACLU faces an identity crisis. And Professor, you're quoted there in that article. A quote that I pulled out is as follows. I got the sense it was more important for ACLU staff to identify with clients and progressive causes rather than to stand on principle. And then the quote goes on, liberals are leaving the First Amendment behind. By way of context, this was in the setting of sort of more current ethic or sentiment of the ACLU, as opposed to what you might say the spirit and ethics that were sort of, part and parcel of your representation in the Skokie case. Can you and I know there's a lot packed into that, but can you share a little bit that just provide a little context to that sort of ideological tension?
Yeah, it started, in my view, at least the sense that I had is became aware of it during Skokie, but it seemed to me the sentiment that people should be able to be free of any offensive or any offensive or obnoxious speech directed at them or their group became more and more of a priority as time passed with the women's movement and the civil rights movement. The sense was that there were harms that were intangible when you said bad things about people to their, in public discourse, and not necessarily nose to nose or face to face. And it was hurtful. It hurt feelings. And my view was that the ACLU was becoming much too concerned with that as it diversified its staff and increased the number of minorities and the number of women who were on its staff and who were its staff attorneys. They became more sensitive, or the ACLU became sensitive to the interests of the groups that the staff people came from or represented. And that was, to me, the antithesis of what the ACLU was supposed to be doing.
As far as what it was supposed to be doing in your conception, there's a phrase or concept of content neutral defender of free speech. Is that sort of the origin principle that you think that you're referring
to? There's that, which is content neutral. You're indifferent as to content so long as it's legal, and you're not inciting
right
directly and intentionally inciting violence in violation of the existing standards. But it's also governed by neutral principles, which is principles that don't care about who the speaker is and what the message is. And there's been a push away from that approach, and one that parallels what's going on in Europe, which is much more concerned with the interests of protecting the sensitivities and the concerns of minorities than it is with keeping the marketplace of speech wide open.
Sure. Why don't we, and I'll go to Professor Stone for this, we haven't yet touched on the limitations, the well-recognized limitations of free speech. Can you provide some of those exceptions?
Well, there are several different types of restrictions on free speech. One type is what's called content neutral. That is, it's a regulation that says no one can use a loudspeaker in a residential neighborhood after 10 o'clock at night. It doesn't matter what they're saying. It's a content neutral rule. And for the most part, the courts have held that content neutral rules are permissible as long as they serve a reasonable justification. The more troubling form of regulation is basically a content-based or viewpoint-based restriction, which essentially focuses on what it is that an individual wants to say. So imagine, for example, that a city passes an ordinance that says no one may use a loudspeaker in a residential neighborhood after 6 o'clock at night to criticize the mayor, right? That would be very different. And right. The court has come to recognize, and it took a long time for the court to recognize this, is that's much more problematic under the First Amendment, because the incentive for the government to enact such laws is likely to be not a neutral one, but a highly ideological one and a political one that distorts public discourse. And therefore, those types of restrictions are basically virtually per se unconstitutional.
Right.
And again, it took the court a good half century to get to that point. But that's pretty much where we are today, except as David said, there are some types of speech that are regarded as low value. like commercial speech or defamation, or obscenity, or incitement to violence. So there they tend to have a less demanding standard. But short of those categories, basically the court has been extremely protective of speech when the government is trying to regulate it because of the message that is being stated.
Sure. We have, I think the pandemic provided a variety of examples of tensions about what speech is appropriate versus, I mean, whether you say appropriate or legal, we can use any terms we want, but there's been a big discussion about it. There was recently the Missouri versus Biden case, which is an injunction entered by a federal judge against the Biden administration to cease communications with social media and tech companies for purposes of moderating content. That is related in large part to what is referred to as the Twitter files, which were predominantly published on Twitter post Elon Musk's purchase, which purport to show or expose a lot of those internal communications. And related to that, there have been hearings on weaponization of federal government that have been held, including bringing in witnesses such as journalists Matt Taibbi, Michael Schellenberger, Robert Kennedy Jr., who's the president for a presidential candidate in the Democratic Party, was also one of the folks who testified. That's all sort of that's probably one cluster of activity. There are plenty of others we can talk about too. But I like to dig into a little bit the concept of the federal government communicating, if not pressuring, social media companies, and how that relates to First Amendment concerns and public square type discussions. Even though Twitter is technically private, there are a variety of issues there. But this is where people are getting. This is the new media in many ways. Yeah.
Take a crack at that, Jeff.
Sure. The issue in particular here is to what extent the government is permitted to encourage or to coerce speakers, in this case, Twitter, not to publish or to publish certain things. As a general rule, one would assume, although there's no case law on this that I can think of, one would assume that the government cannot prohibit you from expressing speech or require you to express speech unless that speech is unprotected by the First Amendment. And that would be fairly obvious that the government can't do that. So the government cannot tell Twitter or Facebook that you may not publish anti-Biden messages, and if you do, we will go after you. That would clearly be a violation of the First Amendment. The tricky thing is when the government does not threaten legal action, but simply argues you shouldn't do this because it's bad speech. It's harmful. So imagine if the New York Times is in possession of national security information, and the New York Times wants to publish it, but the government goes to them and says, look, this is going to be very harmful to national security. That would presumably be perfectly okay. It would inform the New York Times about what the potential dangers are, which they might not otherwise know about, but it leaves the decision to the New York Times.
Right.
On the other hand, they say to the Times, you cannot do this. Then that raises a direct First Amendment challenge because it's basically the government ordering something. And the problem is the line between the two. So what I gave is two simple examples, but the reality is when the government says, this is bad speech, we think you shouldn't publish it, they're not directly telling somebody, we're going to put you in jail if you do this, but they may create an incentive on the part of the potential speaker not to speak.
Sure.
And that's problematic. And that's sort of the gray area in this context.
Right. So we're coming pretty close to time here. But I wanna end on is the concept of how the First Amendment protects, promotes, preserves democracy. And I'll share I believe in Animal Farm there was a preface which I believe was called The Freedom of the Press, and Orwell had not published it along with that book. It was published later, but the very basic concept, as I understand it, is that England and the West shouldn't get too high and mighty about Soviet, about the Western system being better than more democratic than the when it comes to thought and speech than the Soviet system, because we have in the West, Orwell was saying, sort of social forces that tend to suppress speech and even thought that are less obvious and operate in ways that are more subtle, and that we should be paying attention to those because they actually stifle our thought to some degree if we're not careful. And that's sort of my own paraphrasing of it. But how do you find that to be a reasonably meaningful sentiment, and how, if so, does recognition of that promote democracy and the importance of free speech?
David?
Well, I'm not sympathetic to that viewpoint, because it seems to me that one thing that has to be understood is that to engage in advocacy in public places, and to engage in advocacy on important issues takes guts. So there's going to have to be some courage involved. So that it's important not to, I think, turn something that is regarded, and I'm thinking of the case, Missouri versus Biden case, not to turn jawboning into true censorship, that there has to be a real bite. There has to be a real threat of tangible legal consequences, that so the government has to say, if you do A, or if you say A, we will do B, and punish you. We will prosecute you, for example. And I'm thinking of Bannon Books versus Sullivan. And we have the capacity to do it, and will do it. So you better be careful. That, to me, is the kind of line that's an appropriate line to be drawn. Orwell's line is way before that, because, like I say, almost anyone can be intimidated. They still have to stand up at a certain point.
Right. Sorry.
I don't know if Jeff agrees with that, but
Absolutely.
Yeah, and I think that's probably a great place to end, due to the nature of the principle itself, and also because we're out of time. So I wanted to thank you both most sincerely for being here and sharing your experience and insight with us, as this is obviously a critical issue we could talk about for so much longer than we have today. So thank you very much, and thanks to our viewers for tuning in to this installment of You and the Law.